Thank you. Honorable Senators, we're meeting to continue our study of the subject of Bill C-15, the Budget Implementation Act, specifically the elements contained in Divisions 30 and 31 of Part 5. For our first panel, we're pleased to welcome Mr. Nick Covelli, Deputy Chief Administrator of Administrative Tribunal Support Service Canada, Ms. Edith Bramwell, Chairperson of the Federal Public Sector Labor Relations and Employment Board, Professor Nicholas Bala, Family Law, Queen's University by video conference. We'll begin with opening remarks before we move to questions from the members. We'll start with Mr. Covelli, followed by Ms. Bramwell, and then Professor Bala. The floor is yours individually for 5 minutes, and we'll have those presentations. Please proceed, Mr. Covelli.
Thank you. Good morning, Honorable Committee Chair and members. My name is Nick Covelli, and I am the Deputy Chief Administrator of the Administrative Tribunal Support Service of Canada, the ATSSC. I'm pleased to appear before you to take part in your pre-study of Part 5, Division 31 of Bill C-15. I would like to begin by briefly describing the role and mandate of the ATSSC. The ATSSC was created on November 1st, 2014 with the coming into force of the Administrative Tribunal Support Service of Canada Act. The ATSSC provides support services and facilities to several administrative tribunals through a single integrated service point. The tribunals that we support are listed in a schedule of the Administrative Tribunal Support Service of Canada Act. By consolidating the resources of these tribunals, the ATSSC optimizes capacity and ensures access to the specialized services these tribunals require. These include registry services, research, analysis, legal services, as well as internal services such as human resources, IT, and finance. The ATSSC's mission is to equip the tribunals with the resources and expertise needed to deliver fair, impartial, and efficient justice to the Canadian public. One of the tribunals in the ATSSC Act is the Federal Public Sector Labor Relations and Employment Board. Pursuant to acts of the Yukon legislature, members of the Federal Public Sector Labor Relations and Employment Board are also members of the Yukon Public Service Labor Relations Board and the Yukon Teachers Labor Relations Board. Ms. Bramwell, who is next to me, is the chairperson of these three boards. Moreover, long before the ATSSC was created, the predecessor of the Federal Public Sector Labor Relations and Employment Board had a cost recovery arrangement with the government of Yukon for the work the federal board did in support of the Yukon boards. However, when the ATSSC was created in 2014, the Yukon boards were not added to the schedule of the ATSSC Act. Only the federal board was. The ATSSC did continue to provide support services to the two Yukon boards and recovered the related costs from the government of Yukon in accordance with a memorandum of understanding. The proposed amendments to the ATSSC Act will make the support we provide to the Yukon boards more clearly defined. The proposed amendments will create a Schedule 2 to the ATSSC Act, which will allow the Minister of Justice to add territorial bodies to the schedule once conditions are met. Specifically, the proposed amendments will provide a legislative vehicle to recover all costs incurred by the ATSSC from the government of Yukon for supporting the two Yukon boards. This will also extend to other territorial bodies as required and once conditions are met. This will be done if the minister is satisfied that the Yukon will cover the ATSSC's costs. Therefore, the proposed legislation will not increase the expenses of the Government of Canada. To conclude, these changes will strengthen our ability to provide stable, efficient, and accountable support to territorial bodies, including the two Yukon boards. Thank you again for having me this morning, and I'd be happy to respond to any questions you may have.
Thank you. Ms. Bramwell.
Thank you for the opportunity to appear before the committee. The FPSLREB is the labor board for federal public sector employers and bargaining units. In addition, we have a federal mandate with respect to 2 Yukon boards, as you've just heard. This complex and unusual Yukon mandate has endured for more than 5 decades over the various iterations of the federal public service labor boards that have existed since the 1960s. The proposed amendments are of direct relevance to this little-known aspect of our mandate. As part of long-standing federal territorial agreements, the federal government supports an arrangement whereby the Yukon boards are populated by FPSLREB members and are chaired by the FPSLREB chairperson, myself. This arrangement is set out in 2 pieces of Yukon legislation, the Public Service Labor Relations Act and the Education Labor Relations Act. Those acts were drafted as mirror images of the federal legislation of the day. The federal and territorial acts remain highly similar to each other even 50 years later. Like the FPSLREB and its predecessors, the Yukon boards are independent quasi-judicial boards. However, the federal board handles a much higher volume than the Yukon boards. Files related to the Yukon boards amount to less than 1% of our total files. The concurrent tenure of our members as Yukon members flows automatically from our federal governor and council appointments and the Yukon legislation. FPSLREB members may hold concurrent roles as territorial members pursuant to Section 5.2 of the Federal Public Sector Labor Relations and Employment Board Act. The 2 Yukon Public Service Boards oversee Yukon collective bargaining regimes. Yukon Public Service Board members determine matters including essential services disputes, bargaining unit scope and exclusion, duty of fair representation complaints, and work stoppage disputes. Yukon adjudicators, mediators, and conciliators, who are separately appointed by me as chairperson of the Yukon boards, deal primarily with collective agreement grievances. Administrative support for all 3 boards has always been provided federally. These support services are currently exclusively provided by the ATSSC, as you've heard, and were previously exclusively provided by our board's predecessors. The ATSSC Act mandates it to provide support services to the tribunals listed in that Act. The FPSLREB, as of this moment, is listed in that Act. The Yukon boards are not. Despite this, the ATSSC has provided Yukon support services since its creation. The Yukon government and the ATSSC have always reached agreements contained in memoranda of understanding for cost recovery. The proposed amendment reflects this long-standing practice. Despite its concurrent roles, the FPSLREB's mandate comes exclusively from the federal government. It was and remains the federal government's prerogative to discontinue the arrangement, providing that the Yukon's public service labor boards are populated by FPSLREB members, should it ever wish to do so. The proposed amendment does not change this. The proposed amendment brings clarity and certainty to the provision of the administrative services that support this long-standing arrangement between the federal and Yukon governments. I would be pleased to address any questions or concerns that you may have.
Thank you. Professor Bala. Your microphone is off, sir.
Thank you, and thank you for that helpful hint to an old professor. My name is Nicholas Bala, and I would like to say good morning to the chair and all the members, and thank you for having me here today. I'm going to be speaking about the proposal for the increase in the number of judges in the family court, the Unified Family Court. I am a professor at Queen's University. My main area of research has been in family law. I've written very extensively on issues related to family law, family justice, young offenders. I've written many books and articles, and my work has been cited by levels of all court in Canada, including the Supreme Court. And I've had the privilege of appearing before both Senate and Parliament and House of Commons committees on a number of occasions, and had a contribution to law reform in Canada. Today, I will be speaking about what I would call the Unified Family Court proposal. In the second segment, starting at 11:30, there will be more speakers speaking in favor of the Unified Family Courts. And this issue is in some ways very simple. Having more Unified Family Court judges will improve access to justice and will help parents and children have better outcomes. Having said that, there is actually a fair amount of complexity around some of the details, and in particular in Canada, because of the federal and provincial jurisdiction and the overlap, there is variation in how this proposal will work in different provinces. But in Ontario in particular, there is a need for more family court judges. Historically, the courts in Canada have been characterized by having a generalist jurisdiction at a superior court level, federally appointed judges, and also having a second tier of judges in the so-called provincial courts, territorial courts, that have often had a more limited jurisdiction and frankly dealt with people with more limited means. That resulted in two tiers of family justice, two tiers of justice, duplication, inefficiency, delay, the possibility of inconsistent or even conflicting decisions, and a lack of having specialized judges deal with the complexities of family law and family life. Now, in many parts of Canada, including outside of Quebec, and if there are questions, I can certainly talk about the Quebec model, which is quite different. And again, Alberta and British Columbia are different again. But in most of Canada, we are moving towards having unified family courts that have judges appointed by the federal government, paid by the federal government, but with support services provided and a range of services provided by the provincial governments. And having in Ontario, we have about half the province in terms of population has a unified family court, including where I live in Kingston. But a significant portion of the province does not have a unified family court. And in particular, in the Greater Toronto area, there are continue to have these two tiers of family justice, which is inefficient and, as I say, unfair, and often results in delay in the court process, and sometimes results in judges who do not have the experience to deal effectively with family law cases, dealing with them. This is particularly a concern at the pre-trial stage, where almost all cases are actually resolved. We've been moving towards unified family courts. The first unified family court was established in Hamilton in 1977. It was intended to be a pilot project. I think it was very successful. There was an initial report in 1987, the Zuber report recommending its expansion, and has slowly been expanding across the province. Every time it expands, the federal government has to authorize the appointment of more federal judges. And I realize it's a sort of federal provincial issue. The federal government is paying a little more for judicial salaries, but it results in enormous overall savings to the justice system and improves access to justice, helps deal with legal aid issues, and provides support services. In general, I'll talk now just for a moment or two in a very general way. Having unified family courts means that the judges are experienced and can deal with cases in a better and in particular a faster way, which is reducing delay. The delays in the family justice system across Canada, and especially in Toronto, are enormous, which places great stress on parents and children and families, and also what we need is more judicial case management, which is much easier to arrange if there is a unified family court. This proposal, I think, is very important and should be supported. That doesn't mean that it's resolving all the issues in the family justice system. For example, there are issues around cases where there's concurrent criminal and family proceedings. We have an integrated domestic violence court right now in Toronto. That should be expanded. I can certainly identify areas where I think we need more changes. Thank you very much. I look forward to your questions.
Professor, we'll now move to questions from the senators. First, Senator Batters, followed by Senatrice Maville-Deschênes, Senator Simons, Senator Dillon, Senatrice Udar, and Senator Tanis in that order. 5 minutes, please.
Thank you very much. Thank you to all of our witnesses for being here, and Professor Bala, it's very interesting to see you here. I just recall your textbook was the family law textbook in law school. It probably still is, even this many years after I've finished that. And though I didn't take family law in law school, that was an area that I did a significant amount of practice in when I did start practicing. So thank you for all your work in that area. And given that vast experience, I want to address my questions to you on this. Right now, we actually have, as of December 1st, they put out a new table, and across Canada, there are 39 vacant federally appointed judicial positions, and I just looked it up. That includes 12 in Ontario. So, given that, right now they're allocating judges. I'm sure it's probably from the, and you can correct me if I'm wrong, but I think it's from the from the general division. I'm not sure if that's what you call it in Ontario. That's what we called it in Saskatchewan, into the Unified Family Court. But wouldn't it have been better if the government had and continues to make sure that those vacancies are filled in a timely way to increase the overall capacity of the courts rather than just shifting judicial salaries and positions from one area to another?
Thank you, Senator. Thank you for your kind words about the textbook, which I continue to write in various editions. I should say, and one of the issues is that family justice is often a sort of poor second cousin to the rest of the justice system. And understandably, criminal justice gets a lot of attention. And one of the challenges is right now you mentioned the word general division, and there's a almost constantly changing terminology, whether it's the general division, the high court, the superior court. But there's a federal a level of judges appointed by the federal government, what we could call technically Section 96 courts, that and then there are also those judges have historically had a general jurisdiction. And this proposal is intended to both, I think, increase the number of judges and federally appointed judges, and in particular in the family area. Now, I completely agree with you, and I think everyone does, that we need to, first of all, make sure that vacancies are filled as quickly as possible. And there has been, I'm not, an expert in how and why it's been going. I have to say, my sense is, 39 is a significant number, but it has been higher at some points in the past. And so we seem to be moving in the right direction. Should we keep going? Absolutely. And should we get there more quickly? Yes. And should we increase the number of judges? I mean, I think that's part of the issue, that our society is becoming more complex. The charter is raising issues, requirements for trial within a reasonable time. All of those things contribute to delay in the justice system, which on the criminal side means that some cases are being dismissed for lack of trial within a reasonable time. And on the family side results in enormous stress on families, on parents and children, and that has long-term social costs. So delay is not just an immediate issue; it has a long-term effect on families. In some cases, it's contributing to family violence issues, or family violence issues not being addressed effectively, not making sound child-focused plans in a timely way. So I couldn't agree with you more. The vacancies need to be filled, I think, and you can have someone from the Department of Justice explain what they're doing, but I think it's a very important issue. Yes.
Absolutely, and we're trying to get the minister, but we'll see if he makes some time for us here. Okay, sure. Thank you. Maybe, and of course, Jordan has the vast majority of the media attention on criminal cases and the significant consequences. But as you said, there are major consequences also for family law cases with kind of delays. Given your experience, what kind of family law cases would you say are most affected by delays? And will this increase in the number of judges allocated to the family courts have an impact directly on those kind of files?
Well, one of the things, and one of the things about the unified family courts are they're intended to deal with both private, what we call private divorce separation between unmarried partners, and also child protection. And to me, the most important cases are those where the future of children are being decided, and those that deal with family violence issues. And both of them are delayed as a result of the backlog in the courts. And in some cases that results in victims not being adequately protected, not getting the court orders they need, and certainly children are being left in a limbo while their cases are, and in a very stressful situation, while their situations are unresolved. And so those are the cases that are most pressing. Having said that, economic issues in family cases are also important, particularly dependent spouses who are mainly, but by no means exclusively, women, are being left without adequate support. And I think there's no question that delay is one of the biggest problems in our family justice system.
Merci, Monsieur le Président. Je vais aussi poser ma
Thank
question.
you, Mr. Chairman. I'm also asking a question of Professor Bala. Do you hear the interpretation? Yes. So you briefly mentioned the fact that Quebec's case is a bit different. I saw that legislation was passed or was implemented last June to create a unified family court that would come under the Quebec Court of Appeal. So it's different from the youth courts that we have already in the province. So tell me how this court is different in Quebec. It's relatively new. It's newer to Quebec than it is in Ontario, for example.
And on the one hand, I would not hold myself out as an expert on what is happening in Quebec. On the other hand, I probably know more about Quebec than any other English language family scholar in Canada. I've been privileged to work with some scholars, both mental health professionals and law professors in Quebec. And Quebec has had let's call it a distinct justice system, and in particular, distinct family justice system in many ways, and one that I think in some aspects the rest of Canada can learn from, around a whole range of issues, around mediation services, around the role of children in courts. Quebec has done more to ensure that the voices of children whose parents are in dispute are heard in a safe, effective, but child-focused way. So I think Quebec is a real model. Having said that, as you allude to, in Quebec, there has been the Tribunal de la Jeunesse, the youth court, which is a provincial court and deals with both child welfare cases and youth justice cases. And that is unique in Canada. And I think there's a lot to be said for it, for dealing with that structure. And until now, all of the family cases, the private law cases, have been dealt with in the Superior Court. And my understanding is there's variation. So there are some places where some locations, especially larger centers in Quebec, where there's a more of a specialization and an administration on the family side, and other places where the family cases are just dealt with along with everything else, and there's less specialization. So the move in Quebec is also to have more of a specialized and unified family court structure, which I think is also very welcome. My understanding is that this particular proposal is not dealing with that court, but the issue of lack of judges is a concern everywhere in Quebec, in Canada, and in Quebec. The issues of delay, which are related to the lack of judges, and frankly, sometimes their lack of expertise. And one of the things I believe we have, where we have generalist judges, people who may have had a background in bankruptcy law or criminal law, if they have a trial with good lawyers, I have lots of confidence that we're very fortunate in this country to have a very strong judiciary on the whole, at all levels, at the trial levels and at the appeal levels. Doesn't mean I agree with every decision, but I feel very comfortable living in Canada compared to almost any other country in the world with our process of appointment. And although there are vacancies, the issues of delay occur everywhere in the world. But when we have generalist judges who don't have a family law background dealing with family cases, the biggest concern is at the front end of the system, what is sometimes called conferencing and motions, where a judge just has an hour to deal with a family matter. And if the judge was an experienced family lawyer and deals with family cases on a regular basis, they can often deal with those cases very effectively and move the family forward to some sort of resolution, help them settle the case. The primary thing that we think of judges as deciding cases. In family law, it's the settlement function, which is very important. Also, of course, the trial function. So it requires a set of skills. And the problem when we have a generalist judge coming into a deal with a family case for an hour, it takes the judge an hour just to even get a sense, and the judge says, well, this is a very complicated matter. You better come back in 3 months and we'll have another judge try. And maybe you can have a trial, but because of the trial schedule, it is going to take a year and a half till you come to trial. If you have an experienced family judge dealing with the case, they can often help people certainly move it forward and sometimes settle. The other thing, another aspect of this is having consistent case management. So there are certainly complex issues that need to be dealt with. Many are at the provincial and territorial level.
Merci beaucoup pour cette réponse détaillée.
Thank you.
Thank you very much for that answer.
Thank you very much, Mr. Chair. I had some questions for Mr. Covelli and Ms. Bramwell. I note that in the Act, it says that the Minister of Justice must be of the opinion that there is a satisfactory funding arrangement for the provision of support services. But the ATSSCA does not specify what qualifies as a satisfactory arrangement. So I'm wondering if you can shed a little light about what that would be, and the phrase "be of opinion," what the legal import of that phrase is.
Of course, I can't speak for the minister and what he would consider to be sufficient, but I can share that we are in discussions, or have been in discussions, with the government of Yukon to discuss what would be a fair cost recovery model, and that information will be shared. My understanding is that information will be shared with the minister to inform the minister's decision of whether he or she is satisfied that the sufficient funding mechanism is in place. So to provide a little bit more information or insight on that, what we are talking to the Yukon government about is, like I said, a cost recovery model. So, for example, if one of our registry officers is spending 10% of their time working on Yukon board files, then we will, in principle, recover 10% of their salary from the Yukon government.
The other thing I wanted to be clear, I mean, you've both today spoken specifically about Yukon. And I think the legislation foresees a possibility of this same model working for the Northwest Territories and Nunavut. So can you tell me a little bit how those jurisdictions are now run, and whether I'm correct in my understanding that they would all eventually be part of this system? Or is this really just for Yukon?
So those jurisdictions in general are addressed by the CIRB in terms of their unionized workers. The language territorial has existed in the Federal Public Sector Labor Relations Board Act for the last 10 years without any impact on the number of boards which are served by the FPSLREB concurrently. So to some extent, I think the language may simply be consistent with language which already exists legislatively, but I also want to be clear that it does open up the possibility for proposals whereby other labor boards could be created by territorial legislatures and enter into the same kind of cost-sharing arrangement that the Yukon boards have had in one form or another for almost 60 years now. So
I would imagine, I mean, 60 years ago, the idea of a Zoom call was literally science fiction. So is it simpler now? I mean, 60 years ago, if somebody in Yukon needed something, you would have had to go to Whitehorse. Now, not so much, perhaps. So what is being done remotely and on video now versus?
is done remotely. Certainly all case management, a large amount of settlement is done remotely. Some hearings are still done in person where that is most appropriate. The issue, I don't think, is around distance. I don't want to put myself in the mind of people who were the architects of this arrangement 60 years ago, but one of the problems that you see clearly when you think about the Yukon constituting its own labor relations boards is the extremely small number of cases. The populations of these bargaining units are small. They still have constitutionally protected collective bargaining rights, but they are small. And for them to have a registrar, mediators, a lawyer, it would be very challenging because there's simply not enough work to constitute full-time and barely to constitute part-time positions. As I mentioned, they are 1% or so of our file load for both boards, the teachers and the public service.
It just seems to me that it's sort of a neat.
Left, Senator.
It's a bit of a neo-colonialist structure in which you've got people who don't know the community and don't know the people coming in to make these decisions without necessarily having all the cultural context.
So the people who make decisions about collective bargaining are collective agreement disputes are adjudicators appointed by the board, and there's nothing to stop them from being from the community. The board itself takes the issue that you've raised very seriously, and we engage in, that has increased since I have been chairperson, in-depth client consultation with the Yukon boards. It's always bilateral on a regular basis. Certainly, if the Yukon government ever were to decide we want to bring these boards home, that would be their prerogative, and we know that that decision might be made one day. In the most recent discussions I've had with the Yukon stakeholders, both unions and the Yukon government, they've made it clear that they think that the services that the board provides, whether through the ATSSC or the decision-making and dispute resolution services that the board itself provides, are an advantage for them still.
Thank you very much.
Thank you. Senator Dillon.
Thank you, Chair. Thank you, Professor Bala, for your evidence here today and the information you've shared. We've heard similar information and evidence yesterday, and I note that the Canadian Bar Association is also going to be here later in the panel. This relates to your description and statements around UFC, the Unified Family Courts. For all intents and purposes, everything that you've shared makes a lot of sense in its grounding. And you also, if I could just start here, you mentioned a report from the 80s. I heard you say Zuber. Was that? Did I get that correct? Was it called a Zuber report?
Yes, it was a report by Justice Zuber about ZUBER, about the administration of justice, but he specifically looked at the Unified Family Court and did a report on it. I should say, Senator, one of the issues about Unified Family Courts is what is happening. Quebec has, as I say, a distinct system, and they are moving on this. Alberta and British Columbia, for a variety of reasons that I'm happy to address, although, as you say, the Canadian Bar Association and others will be speaking shortly, have not yet moved on unified family courts. And I know that in those provinces, there is a feeling from many, particularly I think, and again, you'll hear from the Bar Association itself, that it would be helpful to move towards unified family courts one of the things I think that is, from my remarks, family law in general requires a high degree of federal provincial cooperation. And in fact, the remarks that we just heard about the administrative tribunal, almost everything in Canada requires to do with the justice system in particular, requires a high degree of cooperation between federal and provincial governments. And the more they can get along and work constructively, the better things are. But there are also internal tensions within provinces. So, and
I thank you. The information you're sharing is so valuable, and I also have limited time, so I want to be efficient and use what I've been given to take advantage of your time here today. So I want to specifically ask you this question: why is it that BC does not have UFC, Unified Family Courts, if they are as efficient, if they are everything that you've described, and all of the rewards of it, the benefits that families ultimately reap in instances where children are involved, as you suggested. So my clear question to you is, why is BC not on board with this?
So thank you. Yes, and that is a question, and I'd say you really have to ask the Minister of Justice in British Columbia and the British Columbia Bar Association for the actual answer, or an answer. And I think that this has just been a long-standing issue, but I think that there are, and I should say, British Columbia has moved very far in its family justice system. They've made enormous progress, in my view, in the last few years. They've given a lot more resources to family justice and made some changes in the family justice system that, again, some of them would be models for what's happening elsewhere, but they haven't yet moved on this one. And I should say, it's not just hearing from the Minister of Justice, it's also from the Chief Justice of the province, who, of course, won't usually, I think, are not witnesses at Senate committees, but there are ways of getting their views. I think there has been some resistance, and I think partly it comes back to money, in that it's not just the judicial salaries, but it's also the restructuring of the courts and provision of support services. One of the things that I think you'll hear from the Bar Association and the Advocate Society is that it's not just the judges, although it's a significant factor, but where we have unified family courts, it also facilitates providing really important support services. Like, are there mediators, family mediators who are not lawyers, there helping people to settle cases? Are there social workers there helping to provide assessments and interventions? And again, BC is moving and has done, in some ways, I think, a lot of work, but it would certainly help do that work, in my view, if they had unified family courts there. And it would be very helpful to have, witnesses from British Columbia saying, why aren't they doing more? But it does require the cooperation of the federal and provincial government and the judiciaries in those provinces.
Thank you.
Thank you, Professor Bala.
There will be time on a second round. So this next is Senatrice Udar.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. My question will be for Mr. Covelli, but it is also addressed to the other witnesses if they wish to complete his answer. Mr. Covelli, I'd like to speak to you about the Administrative Tribunal Support Service of Canada Act, because you're well placed to speak to us about that. It means, this act, that all of the tribunals listed in the schedule come under the same administrative service, so they could streamline and standardize their practices. So could you speak to the committee about has the centralization of administrative services really, can it function with the territory's governmental independence and Canada's commitments in terms of self-determination and shared governance with Aboriginal or Indigenous peoples in the North? Thank you. Thank you for the question, Senator.
Having pulled all the resources into the ATSSC or LSC data is to develop economies of scale. And these economies of scale allow the ATSSC to support a dozen federal and territorial bodies in a very efficient manner. So, for example, if one tribunal is having a peak in its workload and another tribunal or other tribunals are having a decline or a steady state in their volume of work, then ATSSE can shift resources around to where they're needed most. We're able to cross-train employees and generally have a very efficient way of supporting tribunals. But it's also very important to emphasize that we are just a support service. We respect the independence of the adjudicators of each of the tribunals and boards that we support, such as Chairperson Bramwell. It's them that make the decisions. We just provide the registry services, legal services, and other support services and facilities that they need to do their jobs effectively. And at the same time, obviously, we always fully respect the jurisdiction of the territorial governments as well. I can share that our relationship with our Yukon counterparts have been very good, and we've had very constructive discussions on how we're going to make the cost recovery go forward, work very effectively. Were there any points that you wanted to add?
I would just indicate that it's not a new arrangement that we are talking about. This is something that has endured for a long time, and I certainly understand the question about taking this board home back to the Yukon, but I think ultimately that's a decision for the Yukon to make. If the Yukon wants to do that, it's open to the Yukon to discontinue the arrangement at any time. It's through an operation of the Yukon legislation that we serve our concurrent role. So I think the decision is with them, and they will chart the course that they believe is right within their own legislature.
Merci.
There's a minute and a half if you want to ask another question.
C'est correct, Monsieur le Président,
thank you,
de pouvoir
Senatrice.
donner mon temps aux collègues.
That's all right, Mr. Chairman. I can leave that time to my colleagues.
My questions are for Professor Bala, and I want to show my ignorance here, and I'm hoping for a tutorial. Can you explain? And I've got a follow-up question, so if you can explain in relatively few sentences, what is the overlap that you referred to between the federal and provincial jurisdiction as it comes to family justice? Where is this overlap?
So, Senator, by the way, your ignorance is understandable in the sense that it's a very challenging issue for my family law students, and we spend at least 2 hours on it, and they're still confused at the end of it. And part of the complexity is there's a substantive jurisdiction, so there's the federal jurisdiction for marriage and divorce, the Divorce Act, and there's provincial territorial jurisdiction for different provinces, a family law regime, property regime, child support, parenting. And there's also the overlap between the courts. So there's a so-called Section 96 courts, the federally appointed judges who have jurisdiction over certain matters, and in particular, under the Constitution, only a federally appointed judge can grant a divorce and deal with matters related to the divorce, whereas a provincially appointed judge can deal with other matters, certain other matters. So it's a complex overlap of both the substantive jurisdiction and the court structure, and also the fact that the provinces have responsibility for the administration of justice, and the federal government has responsibility for the appointment of judges. So it requires, especially in the family area, a high degree of cooperation. And I should say there was a period of time historically when the federal government and the provinces were not really talking, or were cross purposes, and there were very significant just problems with the overlap and inconsistency. Now there's a higher degree of cooperation. And for example, on the issue of child support, we have in theory, a federal law that governs child support for people getting a divorce, but they have said if you are in Quebec, you will be governed by a different child support regime than in the rest of Canada. That is, say, the regime of the province of Quebec, which is quite different, and in some cases results in more child support, in some cases results in less. But it's even though it's in theory federal law, it adopts the provincial regime, which on the whole is an effective way of having cooperative federalism. It results in inconsistency between jurisdictions, but it's a much more effective and an efficient system within the province. And family law, to some extent, is locally rooted. So, although there are enormous issues that people move provinces and move countries, they live in one place. And typically, and of course, there are problems when they separate and one moves to another province. But the fact they live in one place requires, I think, benefits from having a more consistent and coherent approach. So, in 2 minutes, you got a 2-hour lecture. I hope that helps.
Thank you. That's great. And actually, I had one other question, and I just wanted to understand, Madame Bramwell. I thought I heard you say that in your opening remarks that the Yukon could decide to patriate everything back, but that there was some condition that carried on that whoever was in the tribunal that Yukon did, that they had to be members of the federal union. Was that right? Did I understand that right? Okay, good. Thank you.
The FPSLREB is created by federal legislation. Our enabling act is a federal act. The Yukon legislature has laws which deem whoever sits in my position to be the chair of their boards. So the Yukon legislature could choose to amend that legislation, repeal it at any time. They have all the power to do that. I would still be the chair of the federal board because the federal legislation would be unchanged. Similarly, the federal government could decide that whatever the Yukon legislation says, they're not content to have the chair of their federal public service board continue with that mandate that the Yukon board would like it to have, and the federal government could indicate, if it chose to do so, that the arrangement was at end. But the unions have no say about that. Well, I mean, they have the say that they can give their opinion and have that opinion heard, but they have no authority over those arrangements.
Gotcha. Thank you. Thanks, Chair.
Senator Duncan?
Thank you. I would just like to express my thanks to Ms. Brownwell, Mr. Covelli for their presentation today, and to my colleagues for the questions about the Yukon. Having been involved in this for some time as a member of the legislature, and now as a senator looking at the federal legislation, this is really cooperative federalism. One point that hasn't been made is that the necessity in part for borrowing, accessing the services of the federal board is the small jurisdiction. And the neighbors can be the head of the union, and the head of the Public Service Commission can have children on the same hockey team. And so it makes a difference to be able to access independent services like this. And the arrangement has existed for 60 years, and it's important to continue that service. And I do note that the Yukon does pay for these services, and that it's truly a mutually beneficial cooperative federalism that enables us to do this. So I respectfully request and I'm grateful for the committee's support for this particular amendment. Thank you.
Thank you, Senator Duncan. Colleagues, we have second round. I have Senator Batters.
I'll go back to Professor Bala because we have your considered expertise here. And I think you briefly mentioned in your opening remarks about case management, so that may well be your answer, but I want to give you more time to note it. My question is, if you were to recommend one priority measure to governments, and not just the federal government, but provincial ones in Canada, to improve the functioning of family courts, what would it be?
That's a very tough question. It's the kind of thing that, people, if there's a one thing I mean, I think on a philosophical level, it's to give family justice more recognition and emphasis, and recognize its importance for the long-term well-being of Canada, because our children are our future. But certainly one change, case management, which is not solely actually either a federal or provincial issue, and indeed it requires the cooperation of the judiciary as much as anything, and perhaps more, would be a very important and effective way to deal with a lot of issues. And even in Ontario, where we have unified family courts, we don't necessarily have case management. And like a lot of issues, it requires a number of players and institutions to come together and to have and to be on the same page. And in regard to the previous senator's remark, the cooperative federalism, or the cooperation between institutions, is critical. And the bar has a significant role. The bench has a significant role. The federal government has a significant role. The provincial government, and there are other professional organizations. Mediators have a national organization, for example. They all have to come together to some extent. And on the other hand, each institution can play a role. And so we had significant amendments to the Divorce Act in 2021, the federal government, and this goes back. It requires the cooperation of everybody, but the federal government probably has more of a role than others. And we really saw that with the Divorce Act amendments in 2021, which have helped push the system a little bit to have more of a child focus, more of a recognition of the importance of family violence and the need to deal with it more effectively, and take account, for example, of the wishes of children. But it does require the other institutions to come along. And we see a really interesting interplay between the legislation or legislative action and the court. So we had a major reform in 2021 of the Divorce Act, and the Supreme Court of Canada rendered a very significant decision in 2022 that referred to the amendments and said those amendments around issues of family violence require more action by judges. And again, we have a certain model of the justice system where the Supreme Court of Canada speaks and other judges follow along, but to some extent there's an interaction there between the trial judges and the appellate court. So it requires a lot of players to come along. I think we, generally, I feel optimistic, or very cautiously optimistic, that we have seen progress, and what is before you today is a small piece of a very complex puzzle. And so when and it's great to say one thing, Professor Bala, you've got the floor here. What do you want to do? There are a lot of things that need to be done and moved along. But this is, what you're talking about today is an important piece, and case management certainly would be another important piece.
Senator Pate.
Thank you very much, and thank you to all of you for being here. My question for each of you is the interplay in family courts, particularly in this province. We know that increasingly clients are unrepresented, and so the interplay between the issues of dealing with the shortage of judges and the shortage of counsel and the inadequacy of legal aid services to support those. And how do you see that interplay impacting these provisions?
So thank you for that question. And I was kind of both sort of flattered and very much challenged by the previous question. If there's one thing you could do, and I said, well, case management is part of it. Legal aid is a huge part of it. And the inadequacy of legal aid, especially family legal aid, because again, criminal legal aid gets and there are all kinds of issues in the criminal justice system. Criminal legal aid gets a bit of a priority. And again, the Jordan decision and other reasons, and of course, accused persons need to have legal aid. But in family, you can represent yourself after all. And that's an enormous problem, Senator Pate, that we see really, and it varies by province and by court level, but at least half of the people who are trying to resolve their family disputes don't have access to legal aid and can't afford a lawyer. And that's a very large chunk of a group of people who have very serious problems. And it's not just the adults, it's their children are very much affected. And so we need to have more support services. And I should say, shifting to unified family courts helps a little bit address that because the system can be a little more efficient. But, the issue of lack of funding for legal aid, and to some extent, one can say coast to coast to coast. But in Ontario, certainly in my province, it's got a lot worse under the present government. They had an enormous cut to legal aid, and that has an enormous impact on parents, especially vulnerable parents, especially women, and their children. And I think that we won't have an effective justice system without having, proper access to justice. And governments, and even academics and myself, are trying to prepare materials for people who are self-represented. So I've been involved in preparing materials. The Parenting Plan Guide in Ontario that a number of provinces have adopted. That's a helpful tool, but it requires a degree of sophistication and education to be able to use a tool like that. And far too many people, of course, have issues of literacy and language skill and so on, that those tools are not useful, and they need human help to resolve their issues. And often, if they have appropriate help, they can resolve their cases without a trial. But the lack of legal aid is, and judges, and I should say one of the values of having a unified family court is you have judges who are experienced in dealing with people who don't have lawyers and who need a patient, knowledgeable hand to try to direct the parties to settle or move their case forward. But legal aid is, yes, if we had our wish list, legal aid would be very, very high on that. And I think you're going to have people from the Canadian Bar Association, the Advocate Society, who can knowledgeably speak to that as well. But it's an enormous issue. And the federal government has a role.
I can't speak to the family law context. I can say that facilitating access to justice for self-represented litigants is one of our biggest challenges. We have had some success within the tribunal community with not with the sort of advocacy that can be provided by legal aid, but with the sort of guidance that can be provided by somebody who's in the role of navigator and simply provides procedural advice to people, procedural guidance to people facing the legal system. But it is a critical access to justice issue.
Thank you.
Thank you. All right. We have 2 minutes left, and we have a question from Senatrice Udar. Senatrice Udar, would you like to ask your question? The answers will have to be in writing.
Monsieur, il reste combien de temps et combien
How much time and how many senators are left?
Minute and a half to ask the question.
Il y a d'autres sénateurs qui veulent poser des
There are other senators who wish to ask questions.
Je vais essayer
Okay.
A question this session.
au comité, on aime ça.
At the committee, we like to hear from witnesses, but we also like doing studies and having analyses and of the statistics. Yesterday, I tried to get some statistics, but unfortunately, it wasn't possible. We're concerned, and I'd like to have your perspective on another issue concerning today the Unified Family Court. Well, you mentioned that there are cases in significant numbers that affect women, children, victims of domestic violence, alimony payments. So how, Mr. Covelli, concerning this reallocation, do you know if there is any gender-based analysis that's done in terms of sending these resources to the Unified Family Court? Does it really help correct the situation, or could it emphasize the inequalities for women, for racialized people, for families that have low incomes? So I'm curious to know if there was any analysis done before deciding how to repurpose these funds.
About Division 31 and the amendments to the ATSSE Act, the changes to the Judges Act are not within my area of expertise, so I would defer to Professor Bala. I don't know if he has that information. Otherwise, perhaps my colleagues at the Department of Justice could help you.
Professor Bala, this is a very important question, but we're out of time, so I'm going to ask you to please provide that answer in a written form. We do want to hear your answer on that question, sir. Are you able to do that?
I'll give you a 30-second answer right now, and
Please.
that is that there's an enormous lack of data, and this was indicated statistics. We don't even know how many people in Canada are getting a divorce. So I completely agree that there's a need for better statistics, better research, better data, and funding for research, including through things like the SSHRC, but the federal and provincial government should be doing more research or funding more research. That is a fundamental. So we don't know a lot of things. So I think that's a great issue to raise, and we look forward to hearing from the Senator and others about getting more funding for this.
Okay, thank you very much. Well, once again, colleagues, to all the witnesses that have come this morning, I express our appreciation on behalf of my colleagues on the Senate committee for taking your time to join us and to give us such good information. Thank you very much for your participation. And colleagues, we will now suspend for a few minutes.